Good afternoon from lockdown London. I'm talking to you, and I'm very grateful for your invitation to talk to you with a few introductory remarks to your important seminar on the rule of law in Sri Lanka, the state of the Republic of Sri Lanka, the state of denial, which is what the government is in and proposes to remain in. I've had the limited pleasure of dealing with a number of applications by torture victims from as long ago as 2009 and counting, and dealing with the government's claim that all is well, that they can go to domestic remedies in the Supreme Court, in the Human Rights Commission, and so forth. Preposterous claims that have been refuted by experts on the ground. So what is the state of denial at the moment, and what is being denied? Of course, we remember the 2009 massacre, the killing of at least 40,000, maybe many more, civilians by the Sri Lankan Army and Navy in their attempt to extinguish the Tamil Tigers. Well, they, to some extent, succeeded, and the Rajapaksa government was responsible for the war crimes that took place. They tried to cover them up, of course, by banning journalists, by banning NGOs, but all except the Red Cross, which they allowed in, purely because the Red Cross has this, I think, unsatisfactory ethic that they will never disclose what they find out. But gradually, what happened has been found out. Initially, caught on cameras, on iPhones, the bodies washed up on the shore, the rapes, the cruelty, the atrocities that were committed in the course of that massacre. And of course, the refugees, 300,000 or so refugees, who, some of them, made their way across borders and told what had happened. They told it to a committee set up by the United Nations Human Rights Commission. It was led by Maris Darussalam, the former Attorney General of Indonesia, and it told a terrible story of what had really happened behind the veil that the government had tried to set up. Let me read the conclusions of that committee just to remind us all. It said that the conduct of the war by the Sri Lankan army represented a grave assault on the entire regime of international law designed to protect individual dignity both in war and peace. It accused the army and navy of indiscriminate shelling of civilian areas and camps, abducting members of the local media, starving civilians in the conflict zone of food and medical supplies, as well as torturing captured Tamil soldiers and raping civilian women. It had justifiably harsh words too for the Tigers and their tactic of holding some of their own civilians hostage. But after a report as condemnatory as this, the Security Council had a duty under its responsibility to protect principle to follow up. It should have been referred, the situation in Sri Lanka, to the International Criminal Court prosecutor. But this was never a possibility because China stymied any action after the report was released, publicly threatening to veto any reference to the International Criminal Court. And that, of course, is one of the great problems of international humanitarian law, that countries like Sri Lanka don't sign up, don't ratify the ICC protocol. And the big five at the Security Council have a veto power, and they veto it whenever they think the action is going to disturb an ally. And that is what China did. That is what Russia does in relation to Syria. That is what America does in relation to actions against Israel. So we have a situation where international law, international criminal law, is not binding, is not effective. But nonetheless, in Sri Lanka, it was effective up to a point. The Rajapaksa government set up a lessons learned committee, although not many lessons were learned, and it went its draconian way. There was a dreadful case where they wanted to get rid of the Chief Justice, who'd shown some understanding and quite legally upheld a Tamil claim. And so they punished her with a bogus act of impeachment. And in my report for the Bar Association of England and Wales, I set out just how unlawful and indeed inappropriate were the impeachment proceedings trumped up against Mrs. Bandaranaike. But nonetheless, in 2015, there was hope. A new united government agreed with the Human Rights Committee that something must be done, that there should be no impunity in this country, that those who were responsible for the atrocities of 2009 should be brought to justice, that torture by police of Tamil should stop, that there should be mechanisms to counter the impunity that had reigned beforehand under the Rajapaksa's. So there was hope. And as the United Nations Human Rights Commissioner has said in her recent report, that after the investigation, the Jerusalem report was published, the government did show some signs of responsibility in reviving constitutional safeguards. But that didn't last long, because after 2019, when the defense minister of 2009, another Rajapaksa, came to power, those constitutional safeguards were watered down. First, says the High Commissioner, the safeguards of constitutional safeguards were weakened by giving the government more power over the judges. And then, of course, they came to nothing. In my recent couple of months or so ago, I had to deal with the claims of the Sri Lankan government that those who'd been tortured and viciously attacked by the security services should have some recompense, because in order to get to the Human Rights Committee for some redress, you have to show that you've exhausted domestic remedies. And in Sri Lanka today, there are domestic remedies to exhaust, although the government pretends that there are. This is what it says. It says that anyone can approach the Supreme Court and get redress. Well, That, of course, is untrue. As you probably know, there's a 1-month time limit, which those who've been tortured, who had to hide or go abroad, cannot possibly meet. So the Supreme Court is not an effective mechanism for ending impunity or for providing redress. And then it says, well, we've got a committee against torture. You can go there. But of course, that remedy is practically unavailable. There have been hundreds of claims made under it, but it's resulted in only 11 cases, 8 of them being acquittal. And pursuing a claim takes years. And unfortunately, there are credible reports of reprisals against those who do bring a claim. So that mechanism for redress is not available. And then there's a fundamental, the National Human Rights Committee we've got, says Sri Lanka. It's mandated to investigate complaints into human rights violations. However, it never supports the victims, it's corruptly appointed, and it only has power, even if it exercised it, which it doesn't, to order conciliation and mediation. No power to order compensation, and only non-binding recommendations. It's not legally independent. So the 3 mechanisms that the Sri Lankan government pretends to the Human Rights Commissioner are effective and adequate, simply are not and can be proved. And I have filed a number of expert reports that show that these mechanisms are not working. So at the end of the day, and I think rather than summarize them, I will read you the conclusion of the Michelle Bachelet only 6 weeks ago, when she reported this about Sri Lanka to the Human Rights Commission. And I think she summarizes the evidence in this way. Nearly 12 years from the end of the war, domestic initiatives for accountability and reconciliation have repeatedly failed to produce results, more deeply entrenching impunity, exacerbating victims' distrust in the system. Sri Lanka remains in a state of denial about the past, with truth-seeking efforts aborted, and the highest state officials refusing to make any acknowledgement of past crimes. This has direct impact on the present and the future. The failure to implement any vetting or comprehensive reforms in the security sector means that the state apparatus and some of its members credibly implicated in the grave crimes and human rights violations remain in place. The 2015 reforms that offered more checks and balances on executive power have been rolled back, eroding the independence of the judiciary and other key institutions further. The beginnings of a more inclusive national discourse that prompted greater recognition and respect and reconciliation with minority communities have been reversed. Far from achieving the guarantees of non-recurrence promised by Resolution 30/1, that was the 215 resolution, Sri Lanka's current trajectory sets the scene for the recurrence of the policies and practices that gave rise to grave human rights violations. So rarely do you get a stronger indictment of a member country than that that I've just read, proposed and put by the United Nations Human Rights Commissioner. She went on, the High Commissioner is alarmed that the space for civil society, independent media is rapidly shrinking. She wants all forms of surveillance and intimidation and harassment against human rights defenders, lawyers, and journalists ended. And she concludes by saying the Human Rights Council therefore is once again at a critical turning point in its engagement with Sri Lanka. Twice before, the Council has lent its support to domestic accountability and reconciliation initiatives, culminating in the 2015 Resolution 31. The government has now demonstrated its inability and unwillingness to pursue a meaningful path towards accountability for international crimes and serious human rights violations, and signaled instead a fundamentally different approach, which threatens to deny victims their rights to truth and justice, and further entrench impunity. So that is the situation that the UN mechanism for human rights redress has come to. The Sri Lankan government will not obey, will not abide by human rights principles. It's the end of the road. Sadly, the United Nations will not act. The Security Council is poleaxed. At the moment, the threat of a veto from China, particularly, stops the Security Council taking any action. Of course, we continue with the International Criminal Court, but it doesn't, because Sri Lanka, of course, hasn't ratified the ICC statute. So, of course, that is not available other than by a reference from the Security Council, which will not refer Sri Lanka. Where do we go from there? Well, we try, of course, bringing cases to the UN Human Rights Committee, a tribunal of 18 experts who examine the situation and can issue verdicts. But they are not binding. They're very helpful as legal verdicts, but they're not binding. ASEAN has an organization to look at human rights. It doesn't do very much. Myanmar and Vietnam and so forth are members, and it never seems to grasp the nettle. So international law is failing. But among the recommendations, and of course, the Human Rights Commissioner this year made a number of recommendations about Sri Lanka, but most of them were based on these possible international law remedies, which are no practical use because they're not binding. But it called upon the government to remove perpetrators from their positions of power, from their roles as diplomats and so forth. It called on them to order the military to stop, and the police to end torture and other violations and stop reprisals against human rights defenders. Well, of course, the government will pay no notice to that. And they did, and they wanted a moratorium on the use of the Prevention of Terrorism Act. That won't work because the government won't stop using it against human rights groups. There was, among these many recommendations, which the government will pay no attention to, there was rather hidden a call to explore possible targeted sanctions, such as asset freezes and travel bans against credibly alleged perpetrators of grave human rights violations and abuses. Now, this is something that I want to say a few words about, because it calls into operation what are termed Magnitsky laws. Now, they are targeted sanction laws, and their great attraction, increasingly, is that they are enforceable. Unlike international law, they take principles of human rights, definitions from international law, but they are exercises of national laws. They called Bagnitsky after a Russian lawyer who was imprisoned back about the same time as the destruction of the Tamils in 2009. He was imprisoned in a Russian prison. And what happened to him was pretty much what happened to George Floyd. He was George Floyd without the cameras. He was beaten to death in a Russian prison. And his employer, a man called Bill Browder, took up his case, wanted to expose and punish all the people, lickspittle judges, negligent doctors, who were in corrupt policemen and law officials who had been responsible for his death. And in 2012, he convinced John McCain and then President Obama to introduce the first Magnitsky Act, which provided targeted sanctions against those involved in serious human rights abuses. And that was followed by the Global Magnitsky Act in 2016, and then followed in Canada, and then in Britain last year, and finally in December last year by the 27 European Union countries. So there are now 31 democracies in the world that have targeted sanctions, Magnitsky laws, to, I suppose, name, blame, and shame the perpetrators of human rights atrocities, and as well, some cases, as serious corruption. So this at last provides a remedy for victims whose perpetrators have got money, whose perpetrators have got positions abroad. The United States has used its Magnitsky Act against certain Sri Lankan generals or people responsible for the killings in 2009. What it does, of course, is an exercise by open societies, by parliamentary peoples, of their power to ban, to exclude, to freeze assets of bad people who hold assets. But more importantly, as the sanctions recently on China over its dealings with the Uyghurs have shown, it also deters companies in the West from doing business. All the fashion houses of the West have now refused to source their cotton from Xinjiang province, where it is picked by slave labor of the Uyghurs. So this is a new way of implementing human rights rules, and a form of punishment for those like the leaders of Sri Lanka who go ahead. And sometimes it hurts them. Sometimes, if they've got commercial contracts or their ill-gotten gains go through Western banks, it can cause them great embarrassment. It can end their opportunities to make money from their human rights abuses. There was a recent case where the US sanctioned Carrie Lam for helping to destroy democracy in Hong Kong. And she complained bitterly that her credit cards wouldn't work, even those drawn on Hong Kong banks. And she had to take her salary, $700,000 US a year, comes to 5 million Hong Kong dollars. She had to take it and keep it in her home in notes, and it was cluttering up her house. Well, that gave a laugh to her victims on social media. But for most, for others, it can be a very serious sanction. And it's very useful. I think a number of Sri Lankan politicians, particularly those with investments in Australia, should be made subject to it. It's very good for what I call the train drivers to Auschwitz, the lickspittle judges who sentence enemies of the state on orders, the doctors who oversee torture sessions and the like. And it means that an increasing number of democratic countries, Japan, actually, its parliament is considering joining the Magnitsky movement, but it does mean that an increasing number of democratic countries are denying their banks, their businesses, their schools, that's important, and universities, and their hospitals to families who are implicated in human rights abuse of one sort or another. And I think this is a fertile area for those of us concerned with human rights abuses in Sri Lanka to explore. At the moment, there is a Magnitsky bill resulting from a report of a parliamentary committee that's about to go into the Australian Parliament. I hope it will certainly be debated. I hope the law will pass. But it seems to me that for the moment, while international law is ineffective, unfortunately, in so many human rights arenas, the Security Council will not act, the Human Rights Committee decisions are not binding. In fact, I think only 30%, recent studies showed, had been implemented. We must look to our own national laws, and we must set up Magnitsky lists of people who, in effect, are ostracized, are named and blamed, and who should have no connection. All these ex-military officers whom the Sri Lankan government is appointing as attachés to its foreign embassies must be declared persona non grata because they're put on Magnitsky lists. So I hope Australia will join the Magnitsky movement this year, as 31 other democracies have. I hope that Japan will join it. I have hopes that Laurasia will encourage Singapore and Malaysia and Taiwan and other countries that want the rule of law to join. And if you want a description of how Magnitsky laws could help in ending impunity in Sri Lanka by threatening those who are responsible for turning it into a state of denial, then I can offer my book, which is published next week, which is, I think, the first book on this new Plan B for human rights, as I've described it. It's called Bad People and How to Be Rid of Them. And it describes this new form of ostracism. The Romans got rid of their people they regarded as bad, but this goes further. It does not only name and shame them, but it causes them embarrassment. I mean, judges, doctors who do bad things, they all love going to Europe and traveling to Australia. They like sending their children to its universities. They like going to the beach even, and sending their parents to its hospitals. I think the way to perhaps persuade them, because international law is faltering, is to ban them, to take their assets, and to stop them entering into transactions with companies and people in the West. That is the way forward at the moment, the only way perhaps to prove to them that the game isn't worth the candle. Thank you for listening.